and welcome to this week's video blog on the law. A concern that some people have after being in a car accident is being found at fault or partially at fault for their accident. Sometimes, fault lies with multiple parties. A common approach used by ICBC and injury defense lawyers is to try and avoid 100% of the blame by saying that the injuries you have suffered were caused by your own negligence. This is called the defense of contributory negligence. It means that your actions or inaction may have contributed to the cause of the accident and therefore your injuries. To rely on this defense, ICBC or a defendant in a personal injury trial must show that you acted in a manner that was not to the standard of how a reasonable person in the same circumstances would act. For example, another driver may have rear-ended you and be at fault for doing so, but the other driver might allege that you sat at green light while you finished a text and therefore were unreasonably blocking the expected flow of traffic. If the accident is reasonably foreseeable and you choose to ignore the risk, and your own behavior contributed to the cause of the accident, you could be held contributorily negligent for your own injuries. However, the law does not require that you act perfectly. It is not enough that an accident or injury was foreseeable in hindsight. For ICBC or a defendant to rely on contributory negligence, they must show that you failed to exercise a level of care that a reasonably sensible person would exercise in similar circumstances. In the example I mentioned a moment ago, obviously a person should not be texting at a stoplight. Indeed, no driver should be handling their electronic device while operating a vehicle at all. So, what happens to your personal injury claim if you're found contributorily negligent? The law regarding contributory negligence in BC comes partly from the BC Negligent Act. This act states that each party is responsible for damages in proportion to their degree of fault for the accident and the resulting injuries. The act also provides that if it is not possible to establish fault on any party, liability will be apportioned equally, that is 50-50. If, for example, 3 cars are involved in an accident and the relative fault of each driver cannot be determined, the court would split the fault in thirds. To illustrate these situations, imagine a scenario where you turn left at an early yellow light and the ongoing car collides with you. At trial, the judge finds you're entitled to $100,000 for your injuries and lost wages, but the judge finds that you're 25% responsible for causing the accident. In this case, the judge would reduce your award by 25%. This is the practical effect of contributory negligence. If you are injured and being blamed by another party for the cause of the accident, seek the advice of a lawyer. Many will give a free consultation. I hope that you have learned something about the law from this blog. Please feel free to like us on Facebook, follow us on Twitter, or subscribe to our YouTube channel to receive notice of our future weekly video blogs on the law. Thank you.